through this. All right. So basically the applicant has given 4 points for their appeal. So I'm going to take each of those points and discuss what it is in those points and then respond to them. So the first point was condition 4 does not apply to the 4th paddle court. And so they're also saying that further paddle tennis courts is to paddle courts erected in excess of 5 courts authorized by the city. Than the 2 paddle courts constructed in 1958. So a couple of things, which I mean, this is going to come up a few times. And one of the main premises, which I think the applicant I don't agree with, is that this decision from 1960 was a decision to allow them to put up the courts, but it had a restriction on it. It had a condition on it, which was not to put another one up within 200 feet. And so just like any decision that the ZBA makes, whether it's to relieve an area variance or increase an area variance, we have the right to do that. And we will, in our decision, cite those things. I don't know if I want to dig back to the supporting documents, but we can if Nkechi thinks we have to at this point. But when those decisions are made by the ZBA, those changes go with the property. So to say that the 4th paddle court and the condition that was created that time in 1960 does not exist anymore, we don't agree with that. So have I enumerated that enough? And
That's fine.
yeah, okay. All right. So item 2, condition 4 has been suspended by the 2002 Supreme Court decision. So also noted here, long before the current ordinance came into existence, BFC devoted the interior and the exterior of its entire premises to its pre-existing non-conforming business as a recreational club. So they also state that the zoning code's bulk requirements are met and the 200-foot setback in condition 4 cannot legally apply. So again, it's a similar situation where they're basically saying that condition of the zoning board back in 1960 does no longer exist, but they're also now saying that due to this 2002 Supreme Court decision, that it does not exist. So, and again, the point was made that it was, let me see if I can find it now because I think it's important. So when you go back to the zoning codes, City of Mount Vernon zoning ordinances from 1949, which were in effect at the time of that decision, excuse me, says the board may affirm, reverse, or modify the decision or order or ruling of the Deputy Commissioner of Public Works. No, I'm sorry, that's for the next one. This one is the Zoning Board of Appeals shall have the power in passing upon appeals to vary or modify the application of any of the regulations or provisions of this ordinance relating to the use, construction, structural changes in equipment, or alterations of buildings or structures for the use of land, so that the spirit of this ordinance shall be observed, public safety and welfare secured, and substantial justice done, and thus may permit, among other matters. So, and it goes to list some other matters that the zoning board, has the ability to, that has power over or decision-making process over that. So now I'm just not sure if I'm answering a Supreme Court ruling properly, because I know we discussed this, and and I know Mr. Templeton said that it was a Supreme Court decision, it wasn't binding, but I don't know if we didn't really, you and I did not discuss that particularly.
The purpose of bringing in the Syracuse aggregate case was just to show that the club was authorized to use the entire premises for recreational use. What's pertinent here is this 200-foot setback does not prevent the club from using it for recreational use. The only
Right.
specific use is a paddle court. They can still use it for, whether it's Easter egg hunts or whatever, they can still use it for recreational use.
Right, okay,
And also there was something in the Syracuse aggregate case that said the holding does not mean that the applicant has carte blanche to do whatever, at reasonable restrictions regarding use. That case of use and definitely regarding the area dimensions, like a setback is an area dimension. So reasonable restrictions can be placed. So this does not affect the club's ability to use the premises for recreational use, the entire premise.
okay, so, and so that was, thank you for that. And again, not to make judgment on the judge's ruling and the use of the Syracuse aggregate. Whether that was a correct decision or not, we're not here to debate. It does not take the power away from the zoning board to make the decision it made, and that decision to stay with the land. And the only way that that decision in 1950 can be changed is by the zoning board itself. Saying, you know what, we're going to change and allow them to build a court within 100 feet. So whatever it is, that's up to the zoning board and the zoning board alone. Item number 3, condition 4 is unenforceable. So here, let me look at Exhibit D. Bear with me, I apologize. Would have made these stickies help me out, but they're not, seem to be. Okay, here we go. So again, this is similar, similarly to before. It's from 1949 zoning ordinance for the city of Mount Vernon. And, the board shall hear and decide appeals from the review and review a decision, order, or ruling made by the Deputy Commissioner of Public Works in charge of the Bureau of Building under the ordinance. The board may affirm, reverse, or modify the decision or under a ruling of the Deputy Commissioner of Public Works in charge of the Bureau of Buildings appealed from as it may deem proper. So again, the applicant is stating that condition 4 is unenforceable, and clearly our zoning code, both then and now, does give us the ability to make these decisions. They make another suggestion that the ZBA had no authority to impose a setback greater than the zoning ordinance requirements, as the ZBA had the same powers as the building commissioner. So the ZBA does not have the same powers as the building commissioner. The ZBA has power. I don't want this to sound the wrong way, but it has power over the building commissioner relative to, well, first of all, I should say more like the building commissioner does not have the authority to set area variances or allow for area variance. They can only interpret what the plan looks like and whether there's a need for an area variance. And in this case, the building department did determine that there was a need for an area variance. And that's why we're here today, because the applicant is challenging that. And so let's see, And then they go further, because again, this is really what they're hanging their case on, is this condition 4. And that it is either not enforceable, it's not valid, or that we don't have the ability to determine its validity. So they go on to talk about the New York's general city law, where it states, let's see, new decision extended. Make sure order requires decision interpretation determination as if the ZBA's opinion ought to have been made in the matter by the administrative official. So they're saying, to that end, all powers of the administrative official from whose order, requirement, decision, interpretation, or determination the appeal is taken, and that to that end, all the powers of the officer from whom the appeal is taken. So they're basically saying again that we don't have the power, that the building to overturn or affirm. And the New York State Code is Exhibit E. Sorry. So this is the New York laws of New York in 1932. The Board of Appeals may reverse or affirm wholly or partially, or may modify the order, requirement, decision, or determination appealed from, and shall make such order, requirement, decision, or determination as in its opinion ought to be made in the premises, and to that end shall have all the powers of the officer from whom the appeal is taken. It also goes on further to say the Board of Appeals shall have the power in passing upon appeals to vary and modify the application of any of the regulations or provisions of such ordinance relating to the use, construction, structural change in equipment or alteration of buildings or structures or the use of land, so that the spirit of the ordinance shall be observed, public safety and welfare secured, and substantial justice done. So again, mirrors really what the Mount Vernon zoning ordinances state as well, as far as what the power of the zoning board is. And then item 4, argument 4, is the club does not need an area variance from condition 4. So again, the premise there is that the 1960 ruling with the 200-foot setback requirement for court number 4 is not an area zoning that is part of that property. Again, when the zoning board makes a decision, the zoning board, again, whether it's to diminish the area required or increase the area required, goes with that property. And again, if the club did not want to embrace that 200-foot, they should have appealed it at the time. And again, that is way past that opportunity. So the other thing that I think is important to point out is when we look at the actual decision by the 1960 zoning board. So there's 5 conditions that were put on the zoning board, giving them the right to put up the 2 courts at the time. Was it, or 3? 3 courts at the time. With some conditions. So one was there shall be no floodlights or other artificial lighting illuminating the paddle tennis courts. 2, That there be locks placed upon the gates of the paddle tennis courts and that the same shall remain locked except between the hours of 9 a.m. and 3 p.m., 5 p.m., hard for me to say. That herein locks or private or hemlocks or private hedges, 8 to 10 feet in height, set close enough to form a screen, be planted around the paddle tennis courts, and be properly maintained at all times. Number 4, that no further paddle tennis courts shall be erected within 200 feet of any lot line. And number 5, that the third proposed paddle tennis court be placed on a line with court number 1 and south of it, as appears on the plot plan, to be a distance from court number 1, which is determined by the board as follows, approximately 24 and a half feet south of the court. So the zoning board went through great lengths to consider this variance to allow them to put the courts up, but also where those courts were to be located. And if you look at remember that picture of the paddle courts, there's 3 courts, and court 1 is the one that's closest, would be closest to south court. So there's 1 court south, and then there's 2 courts east and west on the north side. And so that court number 1 is within 200, is closer than 200 feet to the property line, but they allowed to do that. But then they specifically said you can't put another one up any within that 200-foot line. So they clearly, when you look at that L, there's no, in my opinion, to interpret this is they did not want a 4th court built in that open little section. So again, what that zoning board did at that time was definitely look at the whole thing very seriously and considered what the ramifications would be based on the fact that there was that layout. So let me just see what else deemed to be applicable from. Okay. All right. So let me look at my notes. So getting back to the Syracuse aggregate, the Ketchy did point it out, but I just want to mention it again that decision basically said in conclusion that by allowing Syracuse aggregate to consume their land, that it by in no way gave Syracuse aggregate carte blanche to do what they wanted, and that the town always had the ability to accept or reject additional things on that property. And so what the Bronxville Field Club continues to say is that ruling gives them carte blanche to use that property for anything they want as long as it's recreational. And I think clearly that is, again, totally against the decision from, this is 2002, this decision, right? The Syracuse aggregate. Whatever the decision was, the date is not critical right now. And so, yeah, I think in conclusion, I do believe the building department made the right decision. And so I would ask the other members of this board to, if you have any questions about what I've read, because we haven't really discussed this in this kind of detail. And so just if there's anything that you want or need clarification for or disagree with, let's talk about it now so we can come up with the consensus on where we go with this.
I think I'm pretty much brought up to speed on everything. I don't have any other questions.
Okay.
No, I think it's very clearly illuminated the points very clearly and specifically.
Okay. All right, so I would ask if you guys want me to make a motion, I'm willing to. Normally, I ask the board to do that. And so what we're considering now is whether to uphold the building department's decision to require a use, not a use, an area variance, or to determine that the building department made an error in making that determination.
Mr. Chair, I make a motion to uphold the buildings department decision.
I'll second.
Any question? Any comments? Concerns? Okay. A roll call.
Commissioner Bailey.
Wait, Nkechi, I think may want to say something. I'd like her to do that. If
Would the board want to consider, in addition to that, maybe just sending the plan examiner report back to the building department to modify it by omitting their legal analysis as to why they did not require use.
okay, I know that we spoke about this, and now's the time for us to talk about that, then, all right, so here's what I would, relative to the motion and the second, what I would say is I would like to add to that motion that
So what, draw the motion?
I can add to it, or we can re-motion it.
It's already been seconded.
Okay, so we have to, so let's reject, you want to
I
pull
make a
your,
motion
to pull the motion?
pull the motion that I just.
I'll second.
All right. So we don't have to vote on it since we didn't vote it in, is that correct? All right, so I'll,
The board making a motion to send the plan examiner's report. No authority to do that.
all right, so we, at this point, you've had your opportunity. And you have an opinion. This
I'm
is-
noting my objection in the record for that motion.
Okay.
And reserving-
All right, I haven't even made the motion yet, so I'm not sure what you're objecting to. Right? Has there a motion been made? No, but there hasn't been a motion yet, has there?
I'll object.
All right, so, so, maybe we, can we make,
It's just to make sure that the motion is free.
yeah, I mean, can we make two motions? As to not really, weaken the primary motion.
Give me 1 second.
Yeah, no, it's fine. Drink some water.
Looking at General City Law, Section 81G2. Orders, requirements, decisions, and interpretations. These are the actions the board can take. The Board of Appeals may reverse or affirm wholly or partly, or may modify the decisions appealed from, and shall make such decision as in its opinion ought to have been made. Okay, you can make two motions if what the board wants to do is affirm the building department's determination as outlined in the plan examiner report. And then you can also consider a second motion to
That's directed to the building department itself, not necessarily this case.
maybe affirm it partly as it relates to the 200 upholding condition number 4,
Okay,
and then modify it by
I think I got it.
removing the legal analysis regarding the use variance.
Right, so the motion we would be looking to make is to affirm the building department's conclusion through the plan examiner's report regarding that the court being proposed is within the 200-foot requirement. And
Did I phrase it?
go ahead, yes, yes,
It sounds like the board wants to affirm the building department's determination as it relates to
required.
requirement of an area
Variance.
variance pursuant to condition number 4. And modify the determination by removing the legal analysis regarding the use variance.
So again, we talked about separating them, or again, my concern is, you know what my concern is, right? I think we have the right, but
Okay,
so I think we have the right. I think our motion is to affirm the building department's decision on applying the 200-foot setback requirement. And then I think we would have a separate motion directed at the building department that they
a separate motion modify.
to modify modify that,
And then direct the
Yeah.
building department to
to remove any legal analysis and,
revise their plan examiner report
right,
in compliance with the board's decision.
right, and the code of the city of Mount Vernon. Because I think there was an error there, right? That's basically what we're saying.
Well,
We don't want to affirm-
It creates,
I understand that.
and I know,
That's what I'm trying to-
there were conversations with the law department that, legal analysis really shouldn't find a place in the plan examiner report.
So
Especially when
so-
they're explaining why they're not required.
All right, so then it's completely separate to this decision to affirm. And then it's a separate directive between the zoning board and the planning department that they need to be, they need to be more careful in their, let's make the first motion. And
I'm just.
You're still thinking we need to tie it?
And affirm wholly or partly.
okay,
So are you affirming wholly, which would include that?
right, all right, so then,
So it's holy.
Oh,
no, it's not.
Why?
Because the thought is based on the ZBA's powers and the fact that here, I'm going to say this dirty word that the applicant really just doesn't like to hear, that they are non-conforming use. And so all the regulations behind non-conforming uses, you're in this area, it's, in this case, it's residential, but you've been given the right to put this recreation club on. But anytime you want to do something, you need to get a use variance to add to that property. And so, and the other part of the non-conforming use code is that non-conforming uses are assumed to diminish over time and disappear and go back to conforming within the zone that it's in. And so that is key, and that's why the use variance, that's why the zoning board needs to opine on any time a non-conforming use wants to add to the property. In fact, it goes to say in the code that if the building was to burn down, you don't just automatically have the right to rebuild it. You may have to live without it. And now, obviously, there is a financial component that could be brought forward, and there's a few reasons, but that's not what we're looking at. And anyway, it just goes back to the fact that when they want to put something on that property, they need a use variance. So we think we interpret the plan examiner's report to be incorrect, because all they did, they correctly chose the fact that they need an area variance, but they failed to include the fact that they also needed a use variance. So we don't want to affirm the whole decision, because then it's saying, oh, that decision is correct, you don't need a use variance. So that's really what we're
Makes sense.
trying to figure out as to how this is worded. So Nkechi, I'm looking at you, and
I'm just looking at the plan examiner.
I'd like to renew my objection to the record. Again, to note that this board does not have the authority to determine that a use variance is required, overturning the planning board's decision, the building department's decision, when that wasn't even before this board on appeal. And it's contrary to the court decisions but
so, there's if municipalities, I don't know if I should go too deep here. Stop me if I'm saying too much. So if a municipality staff makes a decision and that decision is wrong, I mean, it's blatantly wrong, doesn't mean that it's allowed to move forward. There are checks and balances. And so we are the check and balance to things that the building department does and the plan examiner does. And when they make a mistake, it is upon us, hopefully, to see that and bring it to their attention so that it's then done properly. And so that's really what we're doing here. We're not saying right at this second, we're not making a judgment on whether you need or you don't need a use variance. However, based on non-conforming law, I think you can figure out where we think it should be. And so based on that, we feel the plan examiner made a mistake. They were right on the area variance, but they were wrong on not saying that you needed a use variance. So we want to make the motion so that we don't wholly accept their plan examiner's report, because there is a part of it that's wrong.
To affirm, it's coming to. Condition number 4. Modifying plan examiner report by deleting its legal analysis of zoning board calendar 1748 Z decision.
Okay, that was a mouthful. Did anybody repeat that?
Repeat, please.
All right, you're not allowed to really make a motion, is that correct? We can't use your words? No, I know it's not your motion, it would be our motion, but we surely want to avoid legal costs for the city and for the applicant, right? We want to get it right. And
in your packet, the plan examiner report is under Exhibit A. You want it to.
it's in here somewhere. You're right on top, but it's not. Okay. So you just look, because they did check out zoning board, planning board, and architectural review board. But the key is their zoning board approval is required for area variance. Is that where you're saying they're jumping into a legal?
No, that's fine, area variance.
Oh, so this is one of three. This is on the first page. I don't have.
And then modified by
Two and three.
all language related to this area. Maybe you can-
Okay, I'm gonna try this. So I move that we partially affirm the plan examiner's report and the building commissioner, is it the building commissioner's decision or building department's decision to require an area variance for, why don't I see that in here? You said item 4?
Went to condition number.
Yeah, no, but I'm trying to follow the plan examiner's report and why don't I see that comments and. Gonna catch you, where are you seeing even in this? This is from Sean. No, it's not. It's from Patrick Holder. Okay. Okay, I see it. All right, so I move that we partially affirm the plan examiner's report and the building commissioner's determination regarding the need for an area variance based on condition number 4 of the zoning board calendar number 615-Z decision. And that we request, no. And that the plan examiner's report refrain from the.
Omit all language regarding.
Okay. And that the plan examiner's report now omit any language
Analysis.
and analysis referring to land use,
Use variance.
referring to use variance. Okay, did we do that? Did we
Chair, if
get
I'm
it?
gonna be heard. I don't think you want to leave alas, you want to leave an ambiguity as to whether a use variance is required. When you just delete the whole thing, I think it's an ambiguity. I thought I heard the chair a moment ago say that a use variance was required.
Well, that is,
This is why it should be omitted from the plan examiner. It's now we're getting into a legal argument. And they're simply explaining why they did not require use variance. Usually the plan examiner report checks off what is.
all right, so we're not gonna make the basic statement that there should be a use variance. We're gonna say they need to remove
Omit all that
all that language.
regarding use variance.
Okay, and then we can instruct separately that to have like an internal, what does non-conforming, what non-conforming zones require? I mean, obviously there's a need for education. But that's an administrative, internally, a separate issue, right? So that when they look at these kinds of things, that they will look at them hopefully, in a better light, with more information. All right, so can you read back what I said? Because I don't think I can say it again.
I'm gonna try.
All right,
Motion to partially affirm the building department's plan examiner report regarding area variance, condition number 4, and request that the plan examiner report omit any language regarding use variance.
And modify the plan examiner report. to omit
so modify the plan examiner's report to omit.
The ZBA is hereby modifying it. Then you send it back to the plan examiner report to reissue.
To look at the plan again. All right, so if you could read that again, let's try it.
Motion to partially affirm the building department's plan examiner report regarding area variance, condition number 4, and request modification of the
And the report is hereby modified by omitting
Omitting
all
any-
language and analysis.
language and analysis of use variance.
Regarding use
Regarding
variance.
use variance. Okay.
Give it to me one more time, I'm sorry.
Motion to partially affirm the building department's plan examiner report regarding area variance, condition number 4, and request that the plan examiner report, and request that the plan examiner modify. It's,
And it's not a request, the zoning board
Okay.
has the ability. to
and,
modify
and modify the plan examiner report to admit any language regarding use variance,
Language and analysis.
language and analysis. Okay.
Shall I read it? So it's official and it's.
Read.
Well, I don't know, but I'll
My
try.
scribble?
It's not shorthand, is it?
No.
Okay. By the way, everybody, thank you for indulging us. So I'm going to make a motion to partially affirm the building department's plan examiner's report, specifically regarding the area variance condition number 4. And for the plan examiner to,
So the zoning board is.
The ZBA modify any language and analysis regarding use here.
and
The
modify,
ZBA.
no, so it's omit, right?
The zoning board hereby modifies.
Oh, okay, all right.
By
And, okay.
omitting
Okay, so one more time. Motion to partially affirm the building department's plan examiner report regarding area variance condition number 4 from the it's in the record here, from the ZBA calendar number 615-Z decision. And the ZBA hereby modifies the plan examiner's report, omitting any language and analysis regarding use variance. Do I get a thumbs up?
by omitting. Yes.
Just make sure that we are.
The Zoom isn't working. Somebody has texted in. Okay, so is everybody clear on what this motion is? Ketchy, you're comfortable ultimately with it? I know you're not, you'll never be comfortable because you're a lawyer, so. And you know what? It's hard to be comfortable when there's lawyers involved. So, does anybody want to second the motion?
I second the motion.
Okay, you on the question? Any questions regarding it? Last chance to modify. All right, we're good. Take a roll call.
Okay, Commissioner Bailey,
Yes.
Commissioner Boyle,
Yes.
Commissioner Castillo, Chair Justino.
Yes,
Okay, 4-0, agreed.
okay. Thank you for indulging us.
Yeah, I'll try.
There was a third person.
And as far as that, they're gone.
I'll speak to you, yeah.
The fact that they actually. Yeah.
Okay,
Give it once the meeting's up. Okay, that might be.
you know this.
She wants the recording. Because they did it. You have.
Chairman,
Oh, I'm sorry.
please explain that in English and not legally.
So we affirmed the building department, so the building department determined they can't put it up, they need an area variance. We agree with that.
Okay,
But we're also telling them that there's some errors within the plan examiner's report. They
right,
need to omit some language and rethink what they presented to us.
okay.
Mr. Chair, the risk of belaboring this, it's a clarification. Is the board determining at any time that a use variance is required, even that issue?
Oh, you want to hear us say that it is, but I think you heard what I said about what I understand about non-conforming use. And I think you're a smart enough guy to understand what how I interpret it. Yes.
Okay.
Thank you. Okay. Not how I'm interpreting it, how we are interpreting it. Okay. I think okay. Not anymore. Thought it was gonna be quicker, but. You know, I forgot to read this. I think to an extent.